We will go to Senator Whitehouse.
Thank you, Chairman. Hello, Mr. Sampson.
Senator.
We have a situation right now in which there is a employee of the Department of Justice who has asserted Fifth Amendment rights against self-incrimination with respect to their conduct in office at the Department of Justice. And that person has, as of the last I've heard, not been terminated. In your recollection and to your knowledge, in the entire history of the Department of Justice, has there ever been an attorney working for the Department of Justice who asserted Fifth Amendment privileges against self-incrimination regarding their conduct in office, who was not terminated and who was kept on as an employee and on the payroll?
I've never looked at that question, and I don't know.
Are you aware that courts and juries are allowed regularly, as a matter of standard practice, to draw an adverse inference, it's called, from the assertion of Fifth Amendment privilege by a witness in a civil case?
I've not researched that issue, and I don't know, and I wouldn't want to venture a guess here today.
All right. In your experience as an attorney, have you ever tried a criminal case?
I have.
Where and when?
In the Southern District of Florida in 2004. I was appointed a special attorney and went and tried a case down there.
That was the one case?
Yes.
Okay. Do you remember the nature of the charges?
Yes, it was a gun case. It was felon in possession of a firearm, and also felon in possession of narcotic with the intent to distribute.
Have you ever tried a civil case?
Yes.
When, where?
I was an associate at a law firm in Salt Lake City for 2 years and participated in the trials. I was not the lead counsel, but participated
Second chair?
Yeah, a handful of cases.
Okay. Should we be concerned with the experience level of the people who are making these highly significant decisions for United States attorneys?
Senator,
and I reference in particular an email between you and Monica Goodling in which she suggested that the U.S. Attorney for the Western District of North Carolina should not be on the list. And now, what do you know, that person is not on the list. Do you know whether Monica Goodling has ever tried a case?
I don't know. I know that she served as an assistant United States attorney in the Eastern District of Virginia for a time. I wouldn't want to, let me just leave my answer at that.
You wouldn't want to what?
I'm sorry, Senator, I just lost my train of thought.
Okay. Well, the question was, should we have any concern about the experience level in terms of actual, I mean, you know, these are people out there making very hard decisions in the real world, and they're under a lot of pressure, and here their careers as United States attorneys are brought to an end. And in some cases, it appears that the make-or-break decision is being made by somebody who graduated from law school in 1999, who may or may not have ever tried a case.
Senator,
It seems pretty remarkable to me.
The decision makers in this case were the Attorney General and the Counsel to the President. I and others made staff recommendations, but they were approved and signed off on by the principals.
On what basis?
They were
Because they were your recommendations, or did the principals look through those recommendations and make an independent judgment themselves as to whether the U.S. attorneys should remain?
I think you'd have to ask the principals.
You don't know?
I think you'd have to ask the principals. I made recommendations, and some of them were adopted and some of them weren't.
I think my time has expired, Mr. Chairman.
I'm not sure you ever got an answer to your last question, but we'll let's end that. We'll stand in recess until 1:45.
Thank you, Mr. Chairman.